Welcome to Constangy Clips, the series of tips on staying ahead of important legal challenges in the workplace and cyberspace. My name is Max Bernas, and it's almost Halloween, so today I'm going to talk about some common mistakes that can be all tricks and no treats for employers. As a labor employment lawyer, it's not Freddy Krueger or Michael Myers who gives me nightmares. No, what scares me is employers who make avoidable mistakes that can result in long, disruptive, and expensive litigation. Not all employers do these things, but here are some examples of practices that will send shivers down the spine of your labor and employment attorney. First, it's scary to find out an employer doesn't comply with wage and hour laws. There is, of course, the federal Fair Labor Standards Act, but also a lot of state wage hour laws, some of which give employees more rights than they have under the FLSA. One common employer misstep: assuming an employee is exempt from overtime just because they're on a salary. Being salaried and being exempt are two different things. Exemption status is determined not just by salary, but also by the nature of the employee's duties. Unfortunately, with misclassifications, if you've made one mistake, you've probably made a lot of mistakes, which can result in a collective action lawsuit. Periodically reviewing job responsibilities and promptly correcting any issues can be the silver bullet that keeps this monster at bay. Another thing that should spook employers is the improper handling of employee terminations. If you don't follow your own policies when disciplining or terminating employees, those employees may come back to haunt you. Employers should have progressive disciplinary systems to address issues like attendance, performance, and less serious misconduct or behavior. If the issues are more serious, you should be able to go directly to termination, even if you have a progressive disciplinary policy. Needless to say, an employee should never be terminated for a discriminatory or retaliatory reason. But employers should also make sure they are able to prove that they acted for a legitimate reason rather than an unlawful one. That way, they won't get bitten in the future. Finally, be aware of the National Labor Relations Act. The NLRA is a federal law that guarantees the right of private sector employees to organize, to take collective action, and to raise concerns about the terms and conditions of employment, among other things. A chilling twist that many employers don't see coming. These provisions of the NLRA apply to both union and non-unionized employees. Many standard employment policies, like those that govern social media or prohibit employees from talking about their pay, can violate the NLRA. If you haven't already done it, you should review your policies to ensure that they comply. Doing so can help keep you out of trouble. Falling into any of these traps could mean peril for your organization. The good news is that your Labor and Employment Council can help you address these issues before it's too late. That's it for today's scary story. Thank you for watching. Be sure to follow Constangy on LinkedIn, Facebook, X, and YouTube for important updates and more tips for minimizing risk as labor employment laws and the cybersecurity world continue to evolve.